Kia ora team. How are my guys? How are my guys? Hope you are all well. This is just me dropping in here for this prefix to these episodes that are coming up. What I'm doing is I'm over at Aotearoa with that relaunch and introducing them to the universe, the DC universe, and what we get up to. So hopefully those episodes will bring some new subscribers over, as is the plan, to piggyback off a channel which isn't shadow banned, to get the DC universe out of this and into the fucking future. Fuck going back. So what I've done is I've taken some episodes that I've selected especially for my guys here at the universe. I've selected a range of those and I've put them in a playlist, and this video will be on that playlist, and that playlist will be at the end of this video as well, just for my guys. Yes. And last but not least, if you haven't seen it, the classification video, please see it, especially if you're a new member of the team. It's like requested readings, because your feedback, especially when you're a member, when you're on the team. Now I'll let you go. To audience, stay safe. For fuck's sake, stay safe, all of you. And we'll see you guys next episode. Ka kite.
This is Exhibit A. And why is this woman called Exhibit A? Well, that will come shortly. But first, to set the mood in the courtroom, Exhibit A is in front of Judge Stevens on a revocation of bond hearing. And why is Exhibit A's bond being revoked? Well, I'll let Judge Stevens take it from here.
We got a problem. I mean, they state that it was deactivated 4 months ago. Where is your monitor?
It's on my leg, sir.
But it's dead, right?
Yes, sir. It is.
It's charged, Your Honor. I think she's charged. It's charged, right? Or is it-
I've been trying.
No, he deactivated it, so it
Well,
doesn't matter.
back in
She can
Jan-
get charged. She can use it as jewelry, but it just doesn't do any purpose. It doesn't serve
I
any
think, Your Honor,
purpose.
she has, I'll let you know kind of what happened in that time period. Can she speak, Your Honor? Can you explain what happened?
Yeah,
I've already talked to
this is your time, because I'm about to make some orders that are going to affect your freedom. Go ahead.
4 months ago, I was pregnant. I ended up being in a relationship with somebody. I didn't know them that well. I do childhood, and whenever time I did that, I was getting away from something. I went there. It wasn't the best situation. I ended up getting pregnant during that time. That person beat me. He tried to sell me, like sex traffic me. I was fighting. He beat me with.
How is it somebody else's fault that you didn't pay for your ankle monitor? How is that somebody else's fault, man?
I was being held captive at the time, and I
For
basically
4 months you've been held captive?
I didn't.
This has been deactivated for 4 months. Nobody does that.
I literally had to scream outside the house for help in Dallas, Texas. You can look his name up. He's actually
Well, did you file on him for kidnapping?
Yes, sir.
What happened in the case?
Bruises. He's personally in jail right now because of this.
All right.
I have bruises there.
Once again, but for 4 months, you haven't had a device that you were supposed to have. And that's your problem. You're charged with deadly conduct here. And there was a good reason that we made sure that we wanted to know where you were. And this happened where?
The incident or with this?
Yes. The incident, no, that you said that this person.
Dallas.
I went to Houston with him. and
What are
he
you
took me
doing in
all the way-
Dallas?
He took me all the way to Dallas, and he took all my.
What are you
phones
doing
and
in
everything.
Houston?
That's what I was trying to explain.
See, that's why we have these devices, so we know where you are at all times.
Yes, sir. And during that time, basically, he took all access to everything. I basically had to stand outside the house and
You made a choice of who to pile up with.
You're right. And
That's your
I
problem.
left that situation. And so I was getting back. And I just never had a chance to pay. I can pay today. And not only that, I don't have no issue. My only thing is
You got a big issue.
I didn't do it.
You got a big issue on this order of the court.
I'm just trying to get past this. I can't go, like, I don't even know what to do. Like, I don't know.
That's where you're headed. I mean, that's
And
where you go when you don't follow the orders of the court. For 4 months, my goodness. I didn't know about this.
And the only reason why you put it on me just to make sure I wasn't late for court, like I didn't show up for court and I showed up for court. That was the only reason why you put it on me. I never been in trouble before. I ain't run.
It doesn't matter. The court can for good cause, any good cause, order bond conditions.
Yes, sir.
But but what you've told me is you decide when the bond conditions and what bond conditions are gonna be followed. Not me, and I'm supposed to be the one setting it. But for 4 months, you have been violating a condition of bond, and then we kind of stumble upon it because we have so many cases, we can't be watching everybody. We have to trust that they're gonna follow the rules. And sometimes it happens where you, a day or two, and there's no harm done, but we're talking about 4 months.
And I still followed.
And then you're getting involved in issues, criminal issues in other
No, I
counties.
didn't get involved in criminal issues.
You were
That's the
part
thing.
of something
No.
that was, you
I
said,
didn't do anything.
you wanna just continue to just interrupt me through this whole thing? It sounds like you're the kind of person though that kind of bullies your way into your way. You want it on your terms, and when you don't have it on your terms, then you interrupt and you make excuses, but the bar is set for everybody and they have to get over the bar. And you hadn't been over the bar in 4 months. And that was something that you had an obligation to tell me as much as the bondsman did. But you haven't been following a condition of bond for 4 months, my goodness. That's serious. Very serious. And what we normally do in the cases like this is your bond is revoked. You're in jail and we'll sit this out until we can dispose of this case. That's what happens in all the cases. Sorry, but you had a chance. I have to be able to trust you, and I don't. This is a big gap of a problem.
I think, Your Honor, the argument she's trying to make.
We're talking about a crime of violence that you've been charged with.
It's no.
Well, you're presumed innocent, but the grand jury says there's probable cause to believe you did. Because of that, I have to rely on that as a probable situation. So that's why bond conditions are set. And that's all we're talking about.
Your Honor, I think the issue was because she got involved with someone who ended up being in a very violent, bad situation, who got taken
I'm talking about 4 months not telling me about it.
Well-
That's what we're talking about.
Well, she just recently got free, and that, so she was kind of held for him for a while. So that's,
No, when I can see that for 4 months, she's been held she's been kidnapped for 4 months, let me know. But I haven't read about that in the paper, and that would make the news. Don't tell me that you hadn't in 4 months had time. And John, here's what we'll do is I'll give you a hearing on it and y'all can produce witnesses, but until then, it defies logic that she has been held captive for 4 months. And I want to see some proof of that.
we'll get that, Your Honor.
All right, all right.
Okay. You're gonna be in custody for now, so.
Your bond is revoked. Yes, because you hadn't had a monitor on it. You hadn't called me about it and talked to us.
Possible.
And it was deactivated a long time ago. That's your responsibility. It's a condition of bond and you must have that or you're not released, You must have that, but I've already, you're gonna interrupt me all day long. Is that what it is? Boy, that's rude.
No, sir.
I mean, if there was a crime for that, you'd be guilty of that one because you interrupt. Anyway, that's what I'm gonna do, John, is those findings and see what y'all, I don't know what y'all plan to do in the disposition, but you can have some time, talk to her before we send her.
Absolutely. That's what I'm about to do.
But I've got to have some conditions that, so we know that she's supervised and you're not being supervised by the court. And that's what you're supposed to be. And you are on your own supervision, which is not the way it works. All right. Well, let me know. Thanks, John. We're here for business. Okay, who else?
What happens next? Well, Exhibit A has gone away with her lawyer and begged him to come up with a plan so she doesn't go to prison. And Exhibit A is lucky, very lucky, as this lawyer is one of the rare ones that has a functioning brain. And he has come up with a cunning plan so Exhibit A doesn't spend any time in jail. And how has he done this? Well, this cunning lawyer's plan is to do a deal with the prosecution. And that deal is that Exhibit A will plead guilty to the original charge as long as they agree that Exhibit A would get deferred probation. And even though it is a serious charge of violence where Exhibit A, one day in front of a bunch of people, pulled a gun and started shooting at her ex-boyfriend, this would not be the one that apparently abducted her, but the one that tried to get away from her. And luckily for her lawyer, and especially luckily for Exhibit A, the prosecutor has agreed if she pleads guilty and accepts the facts of the case, that they will agree that she walks without spending a day in prison. It is a cunning plan, a smart plan, and a lucky plan. What could possibly go wrong? It's a gift horse, but unfortunately someone is curious about what the inside of a horse's mouth looks like. In fact, ladies and gentlemen, you are about to witness one of the dumbest criminal masterminds ever to walk into a courtroom anywhere in the world. One of the dumbest. That is an extraordinary claim. And as with extraordinary claims, they must be backed by extraordinary evidence. And where is this evidence, you may ask? Well, ladies and gentlemen, as they say in court, let me present to you Exhibit A.
22-398-51 is called. Does the defendant who's present with her attorney waive a formal reading of the indictment and the arraignment here? Can we proceed as such?
Yes, Your Honor.
In summary, this indictment alleges that on or about April 15th, 2022 in Jefferson County, Texas, you committed the third-degree felony of deadly conduct. Do you understand what you're charged with here?
Yes, sir.
Yes. If convicted, you face no less than 2 nor more than 10 years
Yes, sir.
confinement in prison, and a fine up to $10,000 can be assessed for any third-degree felony. Do you understand?
Yes.
An agreement has been reached in this case. Can you read that into the record?
Yes, Your Honor. The agreement is a cap of 6 years.
6 years?
Yes, sir.
All right, so we're looking at no less than 2 nor more than 6 years in
Right.
prison. Deferred or unadjudicated probation up to 10 years. An agreement has been reached. Again, where whatever sentence shall not exceed a cap of 6 years in prison. And is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to this indictment charging you with the third-degree felony of deadly conduct? Guilty or not guilty?
Not guilty. I mean, guilty.
You got to pick one.
Not guilty. I mean, sorry, guilty.
What's your, think about it, relax. Okay, what is it you're going to plead? You've pled not guilty twice.
I have to plead guilty, saying there's no doubt.
Are you guilty or not guilty? That's the question.
Not guilty.
Okay, all right. Well, that's okay. Yeah, you can't force you into this. All
I'm
right.
guilty. I mean, guilty. Sorry.
Oh, no, this is,
Judge, I
I'm
don't.
guilty. I didn't understand the question. Sorry.
what did you want to say, Mr. Lane?
Just since she's pled not guilty twice, I just wanted to make sure she had time to think about it, not just make a rash
Yeah, I
decision.
thought there was a decision made and we were over lunch.
Yes, sir.
and
Right.
Then
Just getting
came
my
back.
words. Sorry.
Ma'am?
I'm guilty.
Oh, okay.
I'm positive. I'm so sure. Judge Stevens. Sorry about cutting you off.
So How do you plead then?
Guilty.
Is that your final answer? Are you pleading guilty voluntarily and because you are indeed guilty of what this alleges?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. And did you sign that
Yes, sir.
voluntarily?
Yes, sir.
Understand it, discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1, tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. Indictment's been read to you. You've read it. And you've thought about it, and you are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived?
Yes, Your Honor, I think.
Okay, I want everybody to
That's
sound in on this.
Yeah.
What?
Yes, Your Honor, I think she wants to move forward today and not do a PSI.
Okay, go ahead.
Your Honor, I would request in this case, my client give deferred probation. Some of the reasons why is that she has no criminal record. She had this, I think she has some pending misdemeanor charges that may be related to this or sometimes after that, but it's not. She has no convictions for that. So the fact that she has a clean record, this was a disagreement regarding her child's father, however you want to describe him. She apparently had a dispute with him. A gun became involved. She had a gun for her protection. And then somewhere along the way, there was a shot fired. Luckily no one was hit with the shot. She has been cooperative in court, even though, like I said, this morning we had an issue regarding the ankle monitor. She was here to be on court on time here, didn't have any issues there. And I think I'm looking at here, the other misdemeanor is pending as evading arrest or detention. I think when the cops got there, she did take off running from them. Or I'm not sure the fact that I know she was charged with evading arrest and detention as part of this offense. Your Honor, this is the case where we were here this morning and her bond was revoked. She, at that point, said she wouldn't have to take the deal. We were kind of working on a deal with the state.
It was revoked because of this.
Ankle monitor, yes, absolutely,
that.
yes.
Ankle monitor.
That me and Mr. Laird started negotiating a deal on this, and we were going to reset it for a little more time to negotiate a little further to try to get her. I was going to request from the state probation, and I think that's why Mr. Laird did offer the cap, whereas they were not going to agree to probation, but they were giving her the ability to get probation from the court. And we just asked the court to give her probation and whatever conditions the court thinks are required to make her successful.
Okay. State.
Judge, the problem I have with all that is the use of a deadly weapon. You know how this county is just turning into just one place after another where everybody's using a gun, and nobody ever settles their fights with words or anything else. I'm trying to remember. I mean, there was a lot of things going on out there. It looked like there were a bunch of people, but witnesses all back up to the complainant in this case that she also had her children in the truck and pointed it at a group of people. And I think she actually fired one shot at the group. When they got to her, she had 3 outstanding city warrants, of course.
How'd she miss the group? We can't hear what you're saying.
I never shot. I never had a gun. I asked them right there to test me for gunpowder residue. They didn't, and they had cameras and everything. And the police even said they didn't see the group. The only people who said that I shot was his recent girlfriend and his childhood best friend. I was in the car. Everybody else can testify and said that I stayed right by an apartment. The incident happened right by the park. I never had a gun. I promise. Mother Grady, I'm gonna pass away.
Well, then how did we get to
Shot fired.
how did we get to this charge if you didn't have a gun?
You know,
Well, but you just played guilty under oath saying you had a gun, that you threatened these people with firearms.
You're in a catch-22. I mean, this is what the crime is that you just pleaded guilty to. And you knowingly discharged a firearm in the direction of a person And that's one of the elements of this crime. That's a problem. You either admit it or you don't. And if you don't,
Extraordinary evidence, ladies and gentlemen of the jury, truly. A criminal mastermind of the fourth kind. To witness someone so lacking in a frontal lobe reminds me of a frog I once saw sitting on a rock on a stinking hot summer's day, trying to figure out what it should do with the fly it just caught, all while his little green ass is burning in pain. And I thought to myself, that is why we are the top of the food chain. But every now and again, we bump into something that takes me back to that day, holding that tube of super glue, looking at Freddie as he started to rise from that smoldering rock. And I thought to myself, I should have used a smaller frog.
so we're
If you didn't
we're
do it,
kind of
now it's time to
impasse.
fight.
I didn't do it. I didn't shoot again. I promise.
Okay, well, we can't go forward with this. All right. All right, well, then, what we'll do is, well, the bond is revoked. And I told you what the bond is, and it's gonna be doubled and she'll be held in custody, but all we can do is put this up for trial as soon as possible and set it for trial. Whatever, everybody says.
I can disagree. I can disagree. Just do probation. I just don't want to go to jail. I really don't. I agree with it. I just don't want to go to jail. If I could just do probation, I accept all the penalties. Yes, please. But I think I just didn't shoot again. I didn't shoot again. I didn't shoot again. I asked him right there to text for gunpowder residue. It's everything, even the police, like the cameras, all of that.
I'll look at it, Judge. I promise I'll look at it really hard. I promise.
Well, I mean, but of course, the only other thing is a no contest plea,
Please, no contest. Yeah, that's what I want to do. No contest.
but they gotta do
Yeah,
that.
that's up to the state.
Now, here's the problem with that is,
They never do that.
if you're honestly saying you didn't do it, okay, that's what's gonna be, because nobody else told you this. If you mess up on your probation letter, you can't come back and say, I didn't do it, you'll go to prison, okay? You could go to prison on the best of ways, you say that now, but there's a lot of things that can trip you up.
I'm gonna try my hardest.
So- If you did not do this, now's the time to say that, and I can look at it, I'll look at it again and talk to people, we'll see. I don't want to take a no contest plea, because you really seem adamant about the fact you didn't do it.
But I also don't want to sit in jail. So I get this probation. I sit right here and take.
Right now, that you can't enter the plea. The state doesn't agree to them. So we have a bond issue that's gotta get dealt with, so.
Yeah, I already had him, I know somebody following him on,
I do not.
notice on, request to respond. I'll file that soon when we have him on here.
All right, but right now the bond is revoked and
Prepared yet.
for
Yeah.
failure to maintain the bond condition of having a GPS device as required. But I can bring her back, you know, next week or
Every week.
whenever, when y'all, as soon as y'all can figure
I
something
think
out.
except for the week of July 4th, this happening, I'm not here.
All right,
I
that is,
am,
that is all.
I am number 2 this coming Monday next door,
Okay.
but that'll be at 1:00, so Monday morning.
Okay.
I'll sleep guilty. I just don't want to go to jail. Can I do that right now?
No, you can't do it now. You've already said enough. You kind of put yourself in a bad position. You can, yeah.
I'm sorry.
Trust me.
All right, what's next?
Come on.
Should have learned. Before I go back there.
Goodbye, frog. Thank you for the memories. Please like and subscribe to see more frogs. And
P.S. I forgot to inform you that over at OTR, it's MEEzi. It's DCA doing OTR, but it's not my voice. Yeah, the people at OTR, like 99.999% of them, have no fucking idea. Like, don't have any clue what the DC universe is, what the project is, who MEEzi is, the first binary is, what my team is, what we're doing over here. They the DC Universe, they're crime. They watch obviously true crime, and they really like court. And best of all, they're a lot like us, really. They are free-thinking thinkers, so it's a bonus. Plus, of course, I use that sense that I used to get all my guys in my team here at the Universe. I use the 8th sense. And what's the 8th sense? Well, that's the sense of humor, right? That's the sense of humor. And if you've got a sense of humor like ours, then please subscribe and ever think about joining our team. Anyways, all is remember. Oh, and the voice. Try to guess who it is. Come back and tell me on this video. Okay. All of you stay safe, and I'll see you guys next episode. Go Kite.